Consumer protection. We are all consumers. We go to grocery stores to buy necessities. We do online shopping. Some apps requires consumer to give their personal information. But what if our rights are violated? What if our personal information are exposed? Do you know your rights as a consumer? Do you know what are the laws, the acts that protect you as a consumer? Well, if you don't know the answers, watch this video until the end.
Republic Act Number 7394, or the Consumer Act of the Philippines.
What is consumer protection? Consumer protection means safeguarding the interest and the rights of consumers. In other words, it refers to the measures adopted for the protection of consumers from unscrupulous and unethical malpractices by the business, and to provide them speedy redressal of their grievances. Why was it implemented? So the Republic Act Number 7394, or the Consumer Act of the Philippines, was implemented to support the provision under the 1987 Constitution, Section 9. When was it implemented? The principal law for consumer protection in the Philippines is the Consumer Act of the Philippines, or RA number 7394. It came into effect on July 15, 1992. What are its objectives? So according to Article 2 of General Provisions, it is the policy of the state to protect the interest of the consumer, promote his general welfare, and to establish standards of conduct for business and industry. Towards this end, the state shall implement measures to achieve the following objectives: protection against hazards to health and safety, protection against deceptive, unfair, and unconscionable sales acts and practices, provision of information and education to facilitate sound choice and the proper exercise of rights by the consumer, provision of adequate rights and means of redress, and involvement of consumer representatives in the formulation of social and economic policies.
Title 2, Chapter 1 of Consumer Product Quality and Safety.
What are its objectives? According to Article 5 of Consumer Product Quality and Safety, it shall be the duty of the state to develop and provide safety and quality standards for consumer products, including performance or use-oriented standards, codes of practice, and methods of tests. To assist the consumer in evaluating the quality, including safety, performance, and comparative utility of consumer products. To protect the public against unreasonable risks of injury associated with consumer products. To undertake research on quality improvement of products and investigation into causes and prevention of product-related deaths, illness, and injuries. Lastly, is to assure the public of the consistency of standardized products. What are the promulgation and adoption of consumer product standards? So according to Article 7 of the same title, The concerned department shall establish consumer product quality and safety standards, which shall consist of one or more of the following: requirements as to kind, class, grade, dimensions, weights, material. Requirements as to the method of sampling, tests and codes used to check the quality of the product. Requirements as to precautions in storage, transporting, and packaging. And requirements that a consumer product be marked with or accompanied by clear and adequate safety warnings or instructions, or requirements respecting the form of warnings or instructions.
Why protect consumers? Simply because in the market, there are a lot of injurious, dangerous, and unsafe products. Prohibited acts. It shall be unlawful for any person to manufacture for sale, offer for sale, distribute in commerce, or import into the Philippines any consumer product which is not in conformity with an applicable consumer product quality or safety standard promulgated in this Act. It is also prohibited to manufacture for sale, offer for sale, distribute in commerce, or import into the Philippines any consumer product which has been declared as banned consumer product by a rule in this Act. Lastly, it shall be unlawful for any person to refuse access to or copying of pertinent records or fail or refuse to permit entry of or inspection by authorized officers or employees of the department. So what are the penalties if you happen to violate such provision? First, any person who shall violate any provision of Article 18 shall upon conviction be subject to a fine of not less than 1,000 pesos, but not more than 10,000 pesos, or imprisonment of not less than 2 months, but not more than 1 year, or both upon the discretion of the court. If the offender is an alien, he shall be deported after service of sentence and payment of fine without further deportation proceedings. Second, in case the offender is a naturalized citizen, he shall, in addition to the penalty prescribed herein, suffer the penalty of cancellation of his naturalization certificate and its registration in the civil register and immediate deportation after service of sentence and payment of fine. Lastly, any director, officer, or agent of a corporation who shall authorize, order, or perform any of the acts or practices constituting in whole or in part of a violation of Article 18 and department shall be subject to penalties to which that corporation may be subject. In case the violation is committed by or in the interest of a foreign judicial person duly licensed to engage in business in the Philippines, such license to engage in business in the Philippines shall immediately be revoked. Deceptive, unfair, and unconscionable sales acts or practices. Article 50, 51, and 52 stresses that the practice of inducing a customer to purchase directly or indirectly a consumer product or services shall be prohibited. Also, for the sake of marketing, concealment and fraudulent manipulation shall also be prohibited.
Thank you, Ms. Olcus. And now moving on, the food, drugs, cosmetics, and devices. What are the objectives? The objectives are Article 20, Declaration of Policy. Second, Article 21, Implementing Agency. Article 22, Rules and Regulation on Definitions and Standards. And lastly, Article 23, Adulterated Food.
declaration of policy is about ensuring the safe and good quality of food, drugs, cosmetics, and devices, and regulating their production, sale, distribution, and advertisement to protect the health of the consumer. In the implementation of the foregoing policy, the Department of Health shall, in accordance with the provisions of the Act of Establishment Standards and Quality Measures for Foods, Drugs, Devices, Cosmetics, adopt measures to ensure pure and safe supply of foods and cosmetics, and safe, efficacious, and good quality of drugs and devices in a country. Whenever in the judgment of the department, such action will promote honesty and fair dealing in the interest of consumers. It shall promulgate rules and regulations fixing and establishing a reasonable definition and standard of identity, quality, feel of containers for food, drugs, cosmetics, or devices. Adulterant is a chemical substance which should not be contained within other substances, beverage, and other foils for legal and other reasons. Food adulteration means anything adding or subtracting with food making it injurious to health. The process of lowering the nutrition value of food either by removing a vital component. Food adulteration has been a very common practice in our country, and we are consuming these foods almost every day, which have numerous harmful effects to our health.
There are 3 articles under this topic, which is Article 67, Applicable Law on Warranties. Second, Article 68, Additional Provisions on Warranties. And lastly, Article 73, Penalties.
Stipulation essential to the main purpose of the contract, the breach which gives rise to right to treat the contract as reputed, and also the buyer can repudiate the contract and can claim damages. Conditions is essential to the main purpose of the contract, the breach which gives the aggrieved party a right of action against the other party for breach of contract. A written warranty shall clearly and conspicuously designate such warranty, which is full warranty and limited warranty. Full warranty if the written warranty meets the minimum requirements, while the limited warranty if the written warranty does not meet such minimum requirements. The warrantor will not be required to perform the above duties if he can show that the defect, malfunction, or failure to conform to a written warranty was caused by damage due to unreasonable use.
If not obeying the law, there will be a penalty, which in Article 73.
Any person who shall violate the provisions shall be subject to fine of not less than 500 pesos, but not more than 5,000 pesos, or an imprisonment of not less than 3 months, but not more than 2 years.
This topic is all about the liability for product and service, and those liabilities are Article 97, liability for defective products. Article 98, liability of tradesman or seller. Article 99, liability of defective services, and of course, the Article 107, the penalty.
Any Filipino or foreign manufacturer, producer, and any importer shall be liable for redress independently of fault, for damages caused to consumer by defects resulting from design, manufacture, construction, assembly and erection, formulas and handling and making up, and presentation of packing of their products. The service is defective when it does not provide the safety the consumer may rightfully expect of it. Taking the relevant circumstances into consider the time when it will be delivered, the results of hazards, but the supplier is not considered defective because the supplier services when that there is no defect in the service rendered and the consumer or the third party is solely at fault. The service is defective when it does not provide the safety the consumer may rightfully expect of it. Taking the relevant circumstances into consider the time when it will be delivered, the results of hazards, but the supplier is not considered defective because the supplier services when that there is no defect in the service rendered and the consumer or the third party is solely at fault. The fine of not less than 5,000 pesos and by imprisonment of not more than 1 year or both upon the discretion of the court.
Advertising and sales promotion is under 5 articles, which is Article 110, false, deceptive, or misleading advertisement. Article 112, special advertising requirement for food, drug, cosmetic, device, or hazardous substance. Article 116, permit to conduct promotion.
Article 123, which is penalties.
These articles is about the advertisement.
It shall be unlawful for any person to disseminate or to cause of dissemination of any false, deceptive, or misleading advertisement by Philippine mail or in commerce by print, radio, television, outdoor advertisement, or other medium for the purpose of inducing or which is likely to induce directly or indirectly the purchase of consumer products or services. To protect the consumer by buying those mentioned products which making a advertisement will not be done without the approved by the concerned department, not to create an erroneous impression of its character. No person shall advertise and make use of any reference to any laboratory report of analysis required to be furnished to the concerned department. Pertinent rules and regulations may apply to the same for consideration and opinion on such matter before such advertisement is disseminated to the public. The application shall be deemed approved and product is registered and approved by the concerned department for use in any advertisement. No person shall conduct any sales campaigns including beauty contests, national in character, sponsored and promoted by manufacturing enterprises without first securing a permit from the concerned department at least 30 calendar days prior to the commencement unless an objection or denial is received within 15 days from filing of the application. The same shall be deemed approved and promotion campaign or activity may be conducted. Any person, association, partnership, or corporation who shall violate any of the provisions of Article 110 to Article 115 upon conviction, be subject to a fine of not less than 500 pesos but not more than 5,000 pesos, or an imprisonment if of not less than 1 month but not more than 6 months. Any violation of the provisions of Article 116 to Article 121 subject the offenders to fine of not less than 200 pesos but not more than 600 pesos, or an imprisonment of not less than 1 month but not more than 6 months, or both upon the discretion of the court.
When was it issued? According to the Department of Trade and Industry, e-commerce, the administration order was issued on July 21, 2006. What is all about? It is all about prescribing guidelines for the protection of personal data in information and communication system in the private sector. The state recognizes the vital role of information and communication technology in the nation. Under the E-commerce Law, Republic Act Number 8792, the Department of Trade and Industry shall direct and supervise the promotion and develop of electronic commerce in the Philippines with relevant government agencies. First, rights of the data subject. To be informed by any data controller whether personal data of which that individual is a data subject are being processed by or on behalf of the data controller. The personal data of which that individual is the data subject. The purposes for which they are being or are to be processed. Second, right to be notified. The information constitutes any personal data of which that individual is a data subject, and any information available to the data controller as to the source of the data, and the processing by automatic means of personal data of which that individual is a data subject for the purpose of evaluating matters relating to. Third, right to information. A data subject also has the right to request the following information: the designation or name and surname, an address of the data controller, the purpose, scope, and the method of the personal data processing, the date when the personal data concerning the data subject was last rectified, the source from which the personal data were obtained unless the disclosure of the such information is prohibited by the law. Fourth, right to access his or her personal data. A data subject has the right within a period of 30 days from the date of submission of the relevant request to receive from the data controller or data processor the information is specified in the preceding section in writing. Fifth, right to rectification, destruction of his personal data, or restriction or further processing of his personal data. A subject has the right to request that his personal data be supplemented or rectified, as well as that their processing be suspended or that the data be destroyed if the personal data are incomplete, outdated, false, unlawfully obtained, or no longer necessary for the purposes of which they were collected. The data controller has an obligation to rectify this inaccuracy or violation without delay and notify third parties who have previously received the process of such data. 6. Right to object. A data subject has the right to object in writing, orally, or any other form to the processing of his or her personal data if such will be used for commercial purposes. The voluntary accreditation is Section 5. Section 5 is a certification shall declare that the privacy policy employed by licensed company and examined by a data protection certifier duly accredited by the Department of Trade and Industry Accreditation Office utilizes commercially appropriate and internationally recognized standard. The certification also covers the trustworthiness of the data protection certifier's practices. The accreditation criteria: the applicant must be a registered Philippine firm. Shareholders and personnel of the registered Philippine firm have never been convicted of any violation under e-commerce law. The applicant must be recognized or licensed to provide data privacy or protection compliance certification by an international organization or firm.
Lawful access to personal data in an information and communication system. To sum up the main points of Section 5, Section 6, and Section 8, the company or organization should ask permission or consent to consumer if they are willing to give their personal information. If the data subject will not give his or her personal information, then we need to respect it. But if they will give personal information, make sure that the data will be handled confidentially with full security to avoid disclosure. Joint Department of Trade and Industry, Department of Health, Department of Agriculture, Administrative Order Number 1, Series of 2008.
What is Administrative Order Number 1, Series of 2008? So this order is about the rules and regulation for consumer protection in a transaction covered by the Consumer Act of the Philippines, or the Republic Act Number 7394, through electronic means under the E-Commerce Act, or the Republic Act Number 8792. Whereas the Republic Act Number 7394 declares that it is the policy of the state to protect the interests of the consumer, promote his general welfare, and to establish standards of conduct for business and industry to implement measures to achieve, among others, the protection against deceptive, unfair, and unconscionable sales acts and practices. Whereas Republic Act Number 8792 recognizes the vital role of information and communications technology in nation building aimed at facilitating domestic and international dealings, transactions, arrangements, agreements, contracts, and exchanges and storage of information through the utilization of electronic, optical, and similar medium, mode, instrumentality, and technology to recognize the authenticity and reliability of electronic data messages or electronic documents related to such activities and to promote the universal use of electronic transactions in the government and by the general public. Whereas the Electronic Commerce Act penalizes acts in violations of the Consumer Act and other relevant or pertinent laws through transactions covered by or using electronic data messages or electronic documents with the same penalties provided for therein. Now, therefore, pursuant to the provisions of the E-Commerce Act in relation to the Consumer Act, the following order is hereby prescribed for the information, guidance, and compliance of all concerned. When was it implemented? According to the Department of Trade and Industry, the administration order was issued on October 20, 2008. What is its scope and coverage? According to Section 1, the order shall apply to all retailers, sellers, distributors, suppliers, or manufacturers engaged in electronic commerce with consumers. These implementing rules and regulations shall be enforced by the Department of Health with respect to food, drugs, cosmetics, devices, and hazardous substances, the Department of Agriculture with respect to fresh, primary, and secondary processed agricultural fishery products, and the Department of Trade and Industry with respect to other consumer products not specified above. However, the Bangko Sentral ng Pilipinas shall assume jurisdiction over financial products and services offered by the financial institutions under BSP supervision.
What are the requirements for adopting fair and reasonable business practices? Retailers, sellers, distributors, suppliers, or manufacturers engaged in electronic commerce with consumers shall adopt fair and reasonable business practices. In this connection, retailers, sellers, distributors, suppliers, or manufacturers shall ensure compliance with the requirements for consumer product quality and safety standards, ensure compliance with requirements for safe and good quality of food, drugs, cosmetics, and devices, ensure compliance with requirements for substances other than food, drugs, cosmetics, and devices that are hazardous to consumer health and safety, and not engaged in any deceptive, unfair, and unconscionable sales acts and practices, honor and accept the responsibilities for consumer product and services, be liable for defective products and service, and ensure compliance with other requirements of the provisions of the Consumer Act of the Philippines and its implementing rules and regulation as fair and reasonable business practices. What are the requirements for adopting fair marketing and advertising practices? According to Section 4, retailers, sellers, distributors, suppliers, or manufacturers engaged in electronic commerce with consumers shall refrain from engaging in any false, deceptive, and misleading advertisement prohibited under the provisions of Title III, Chapter 4, or the Advertising and Sales Promotion of the Consumer Act of the Philippines and its implementing rules and regulation, and shall comply with the advertising and promotion requirements therein, and other advertising and promotion guidelines issued by the respective department in compliance with other relevant laws.
Joint DTI DOH DA Administrative Order Number 1 Series of 2008. Requirements for online disclosure of information. Information about retailers, sellers, distributors, suppliers, or manufacturers engaged in electronic commerce shall provide accurate, clear, and easily accessible information to identify themselves. Conclusion of consumer transaction. Before concluding the purchase, retailers, sellers, distributors, suppliers, or manufacturers shall provide by procedures consumers to opportunity to review and accept or reject the terms and conditions of the contract, identify precisely the product or service consumers wish to purchase or avail, identify and correct any errors or modify the order, and retain a record of any purchase or order transaction, confirmation, acceptance of any offer they make. Retailers should promptly acknowledge receipt of any order confirmation or acceptance received. Original documents. In law, document be presented, it must be original form and submitting by an electronic document it be shown a evidence the data of the message. It is capable of being displayed to the person whom it presented to, and the purpose of those are assessing integrity shall be whether the information has remained complete and unaltered. Any change which arises in the normal course of communication and an electronic document meeting and complying with the requirements of Section 6 or 7 of Republic Act Number 8792 or the Electronic Commerce Act. Compliance of retailers engaged in electronic commerce with the data protection guidelines. Any retailer engaged in the business of electronic commerce with consumers shall comply with the requirements set forth in on original principles for the protection of personal data, on voluntary accreditation, on lawful access to personal data in an information and communication system, on obligation of confidentiality, on security of data provided for under the provisions of the DTI Department Administrative Order Number 8 Series of 2006 or prescribing guidelines for protection of personal data, information, and communication system in the private sector. About the e-commerce and the business regulation will be discussed by Ms. Chris Nicole Teofilo and Ms. Trinity Nicole Ann Natad.
What is e-commerce? Electronic commerce or e-commerce is defined to be the process of businesses trading with other businesses and the formulation of internal processes using electronic links. Electronic business or e-business is a term often used interchangeably with e-commerce. Electronic commerce, commonly written as e-commerce, is the trading of products and services using computer networks or the internet. Electronic commerce includes mobile commerce, electronic fund transfer, supply chain management, internet marketing, online transaction processing, electronic data interchange, inventory management systems, and automated data collection system. Modern e-commerce typically uses the WW or the World Wide Web for at least one part of the transaction's life cycle. However, at present, modern e-commerce platforms now uses the email. When did e-commerce started? E-commerce originated as a standard for the exchange of business documents such as orders or invoices between suppliers and their business customers. This can be traced back in 1948 to 1949 in Berlin. They were using a system of ordering goods via telex. The historical development of e-commerce emerged with the use of networks to exchange money and transfers in the late 1950s as well. In the Philippines, the Electronic Commerce Act, Republic Act Number 8792, was signed into law on 14th of June 2000 by President Joseph Ejercito Estrada. This law gave legal recognition to electronic forms of data messages, documents, signatures, transactions, storage of information, and many others. It provided penalties for access of data without consent. At present, The Department of Trade and Industry is the authority to direct and supervise the promotion and development of e-commerce in the country with relevant government agencies.
E-commerce in the Philippines. The e-commerce market in the Philippines has seen a gradual growth in recent years, as reflected in its revenue figures in 2020. Although the growth in revenue remains low as compared to other Tiger Cub economies in Southeast Asia, the potential for online shopping in a country with the highest daily time spent using the internet is promising. A recent survey revealed that consumers in the Philippines access a merchant's website or shopping apps to buy products or services on any device. As a result, e-commerce expenditures in the country increased as more and more Filipino consumers are choosing to buy from an online store due to the convenience it offers. Do we need permits to do online business? Well, the Philippine government isn't that strict towards online sellers who started a small business during community quarantine to recover from the financial and employment crisis. It is highly recommended to be registered by the government for your business protection. But if you want to get technical about it, you are required by law to comply with tax regulations according to the Revenue Memorandum Circulars. That means an online business is seen by the government as legitimate as any other brick and mortar. And as businesses do, even online sellers are required to issue electronic receipts according to the TRAIN law. Republic Act 8484, also known as Access Devices Regulation Act of 1998, is an act regulating the issuance and use of access devices, prohibiting fraudulent acts committed relative thereto, providing penalties and for other purposes. This law aims to protect the rights and define the liabilities of parties in commercial transactions using access devices by regulating the issuance and use of access devices, which include any card, plate, code, account number, electronic serial number, personal identification number, or other telecommunications service, equipment, identifier, or other means of account access that can be used to obtain money, good, services, or any other thing of value, or to initiate a transfer of funds. Prohibited acts under RA 8484 include producing, using, trafficking in one or more counterfeit access devices, using with intent to defraud an unauthorized access device, inducing, enticing, permitting, or in any manner allowing another for consideration or otherwise to produce, use, traffic in counterfeit access devices, unauthorized access devices, or access devices fraudulently applied for. Multiple imprinting on more than one transaction record, sales slip, or similar document, thereby making it appear that the device holder has entered into a transaction other than those which said device holder had lawfully contracted for. Disclosing any information imprinted on the access device, such as but not limited to the account number or name or address of the device holder without the latter's authority or permission. Any person committing any of the acts constituting access device fraud enumerated shall be punished with A fine of 10,000 pesos or twice the value obtained by the offense, whichever is greater, and imprisonment for not less than 6 years and not more than 10 years. In the case of an offense under Section 9B to E and G to P, which does not occur after a conviction for another offense under Section 9. B. A fine of 10,000 pesos or twice the value obtained by the offense, and imprisonment for not less than 10 years and for not more than 12 years in the case of an offense under Section 9A and F of the foregoing section, which does not occur after a conviction for another offense under Section 9. C. A fine of 10,000 pesos or twice the value obtained by the offense, or imprisonment for not less than 12 years and not more than 20 years, or both, in the case of any offense under Section 9, which occurs after a conviction for another offense under said subsection or an attempt to commit the same. Executive Order Number 264, Series of 2000. establishing the Information Technology and Electronic Commerce Council from the merger of the National Information Technology Council and the Electronic Commerce Promotion Council. This was amended through Executive Order No. 18 Series of 2001. The number of members in the Council and their respective roles are amended to enhance, expand, and accelerate decision-making and ICT-related activities. Republic Act No. 8792, also known as the Electronic Commerce Act of 2000, is an act providing for the recognition and use of electronic commercial and non-commercial transactions, penalties for unlawful use thereof, and other purposes. This act aims to facilitate domestic and international dealings, transactions, arrangements, agreements, contracts, and exchanges and storage of information through the utilization of electronic, optical, and similar medium, mode, instrumentality, and technology to recognize the authenticity and reliability of electronic documents related to such activities and to promote the universal use of electronic transactions in the government and general public. The Department of Trade and Industry, Department of Budget and Management, and the Bangko Sentral ng Pilipinas are given the authority to enforce the provisions of Republic Act No. 8792 and issue implementing rules and regulations necessary. Depending on the severity of violations, penalties under RA No. 8792 include A. A minimum fine of 100,000 pesos and a maximum commensurate to the damage incurred and a mandatory imprisonment of 6 months to 3 years. B. Violations of the Consumer Act or Republic Act No. 7394 and other relevant or pertinent laws through transactions covered by or using electronic data messages or electronic documents shall be penalized with the same penalties as provided in those laws. C. Other violations of the provisions of this law shall be penalized with a maximum penalty of 1 million pesos or 6 years imprisonment. Republic Act No. 11127, also known as the National Payment Systems Act. This act provides a comprehensive legal and regulatory framework which supports the twin objectives of maintaining a payment system that is necessary to control systemic risk and providing an environment conducive to the sustainable growth of the economy. This law also includes the National Retail Payment System, which provides the framework to secure promised gains of modernizing retail payments for the benefit of the consumers, the industry, and the economy as a whole.
BIR Memorandum Circular No. 60 of 2020 Obligations of persons conducting business transactions through any forms of electronic media and notice to unregistered businesses. This circular is meant to give notice to all the people doing business and earning income in any manner or form, especially for those who are into digital transactions or e-commerce. These do not only include partner sellers or merchants, but also the stakeholders involved such as the payment gateways, delivery channels, internet service providers, and other facilitators. Republic Act No. 10173, or the Data Privacy Act of 2012, an act protecting individual personal information in the information communication system of the government and the private sector, creating for this purpose a National Privacy Commission and for other purposes. DTI-DOST Joint Department Administrative Order No. 2, providing implementing rules and regulations on electronic authentication and electronic signatures. The state recognizes the vital role of information and communications technology in nation building, as well as its own obligation to ensure network security, connectivity, and neutrality of technology for the national benefit. These rules apply where electronic signatures and/or electronic documents are used in the context of any commercial and non-commercial transaction, activity, or dealings, whether public or private, occurring between and among parties. Executive Order Number 810, institutionalizing the certification scheme for digital signatures and directing the application of digital signatures in e-government services. The Department of Trade and Industry, DTI, through its Philippine Accreditation Office, or PAO, is hereby designated as the accreditation and assessment body for certification authorities pursuant to its mandate and in accordance with the provisions of the E-Commerce Act. Executive Order Number 334, Series of 2004, abolishing the Information Technology and Electronic Commerce Council and transferring its budget, assets, personnel, programs, and projects to the Commission on Information and Communications Technology. The Information Technology and E-Commerce Council, ITECC, is hereby abolished and its budget, assets, records, personnel, programs and projects, and functions are transferred to the Commission on Information and Communications Technology, CICT, as appropriate.